We're going to wait 5 minutes.
So, Judge Toomey, who runs our Veterans Court, is going to sit down with us after. Oh, here, please. You guys can fill them out before you get numbers. I guess we need receipts.
Hello, everyone, and welcome. We are here to celebrate the publication of this very important book, Transforming Justice, Lawyers and the Practice of Law, which our dear colleague Marjorie Silver and her collaborators have worked on for 6 years, and here it is in beautiful color, a thing to treasure, a thing to be proud of. I'm going to speak for a moment about a metaphor or a theme that runs through several of the essays in the book, and that is the theme of the beloved community. And I want to begin by citing a passage that is frequently associated with, a very well-known passage that's frequently associated with the idea of the beloved community. And it is this very famous passage. I have a dream that one day on the red hills of Georgia, the sons of former slaves and the sons of former slave owners will be able to sit down together at the table of brotherhood. I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin, but by the content of their character. I have a dream that little black boys and little black girls will be able to join hands with little white boys and little white girls as sisters and brothers. And these words which never fail to stir, these timeless words spoken by a man who was a preacher steeped in the Bible, a man who had a doctor of divinity, and one of the great preachers of our time or of any time, are about a kind of beloved community, and they're, in a way, they allude to a broken community. The first instance of brotherhood that we have in the Bible is 2 brothers, Cain and Abel, one of whom kills the other. Cain's name, Cain in Hebrew, has to do with acquiring things, and Abel's name, Hevel, has to do with evanescence. The beginning of Ecclesiastes, vanity of vanities, Hevel, Hevel, that's Abel's name. And he is also the first person in the Bible to die. And this is the context in which the question is put. The question is put by God to Abel, not the same question that is put to so many biblical characters in Genesis. The question is not, where are you? The question is, where is your brother? Now, everyone remembers the answer, am I my brother's keeper? But they forget the question. The question is, where is your brother? And that's the question I think that we always have to ask ourselves. We are all, as in that prophetic speech that I think is, in a way, the animating spirit of a culture of love. The question always is, where is my brother? Where is my sister? You are my brother. You are my sister. And the idea that we can have justice, or we can transform justice, and we can practice law in the context of a community, a beloved community, and in a context of love, is something that I cherish. And one of the reasons why I know that it's possible is because of the time that I have spent in the courtroom of Judge Jack Toomey, who presides in the Veterans Treatment Court, one of the problem-solving courts in Suffolk County. And problem-solving courts are one of many topics touched upon in this book. Judge Toomey served in Vietnam. He has 2 Bronze Stars. And what you see in his courtroom is nothing less than a beloved community. It's a place where justice is done, but justice is done with love. And now it's my privilege to introduce Judge Toomey for a few remarks before we continue with the program.
Thank you very much. I guess I can't call you Harry. I'll call you Dean Harry for those kind words. And certainly congratulations to Professor Marjorie Silver for writing the book. I didn't get a chance to read it, but I certainly will. The words that the Dean used to introduce me, I think, were really something that we tried to apply. And I never put it like that in my courtroom. Only once every 10 days we actually sit in the veterans courtroom. The rest of the time I preside over serious felony cases murders, robberies, etc. in out in Riverhead. But every other Tuesday, I do sit in the Veterans Court in Central Islip, and I never thought of those two words that would go with it, and 6 words that the dean actually said in his introductory remarks. Beloved community, and where is my brother? I wrote them down. Where is your brother is actually what he said. And we started the Veterans Court in 2011, February 2011, when some of our politicians, congressmen, most probably notable Congressman Israel, realized that veterans coming back from the wars in Afghanistan and Iraq were coming back with problems with drugs, PTSD, alcohol, traumatic brain injury, and these problems sometimes intersected with the criminal justice system when they'd be arrested for possession, drugs, drinking and driving, assaultive behavior, domestic violence, etc. And as a result, that was the genesis for the Veterans Court. I think I was picked to preside over it, mainly because I was the only Vietnam veteran, only combat veteran probably in the Suffolk County court system. But we did start in 2011. I had the great privilege of actually starting the court, which I knew nothing about. I had no idea how we were going to do it. And we actually started ourselves. We have mentors that are veterans that work with us every day, that are in the courtroom, and they're a friend to the veterans. They're all Vietnam veterans. Remember all too well when they came home from Vietnam how they were treated, and their creed is never let another generation of veterans will never leave another one behind, and they certainly practice what they preach. And I just want to give just an acknowledgement to one of your colleagues, Dean Rosenblum, who's also a Vietnam veteran, works very closely with me in the Veterans Court and is heading up and doing remarkable work in our neighboring county, Nassau County. And I have to tell you, Ken is one of the most selfless guys I've ever come across. And when I say, where's your brother? And there's one of my brothers sitting right over here. I feel, I spend a lot of time with Ken, and it's certainly my privilege to work with him and to, share these experiences. But we try to, as you know, it's an adversarial system, the courts, and it's prosecutor against defense attorney, a plaintiff against defendant, and we try to do away with that in Veterans Court as much as we can. We have prosecutors, we have defense attorneys, we have legal aid attorneys, and what we try to do is take that out of the equation and treat the veteran when they come in, whatever their problem may be. It may be alcohol, it may be drugs, it may be post-traumatic stress syndrome, excuse me, or a traumatic brain injury, and try to set a program for that veteran and give him the benefit of our experience and also the rehabilitation that he can get. We're very fortunate being in Suffolk County. We have the Northport Veterans Administration right here. And I have a young man, Eric Bruno, assigned to my courtroom who works for us, with us, but he's actually an employee, a federal employee, and sets up all the programs and all the treatment for these veterans. And I don't know if it is in your book, Professor Silver, but in a lot of treatment courts, I know you have one chapter on it. One thing they do in drug court or domestic violence or mental health courts is they use jail as a deterrent. They call it, there is a sanction. They put people in jail. I never, very rarely, only as a last resort will I use jail as a sanction. It's always we try to, if somebody's drinking, he shouldn't be. If he's doing drugs when he shouldn't be, which they never should be, I guess when on occasion they do it, we always try to remedy the situation by increasing, changing, or modifying the treatment that they're getting. So you can come in my courtroom tomorrow and say, Judge, I was drinking over the weekend, and so you might be in for your fourth drive while intoxicated. It's two things. One, you shouldn't do it, but it's really good that you did tell us. A lot of times we have these guys will self-report, and we'll change his treatment. They test positive. I'm not going to put them in jail. I'm going to give them, if they want to still work with the program, we'll give them every benefit of it. And that's what I think so much probably getting out of just meeting Marjorie and listening to people talk about a book and talk about her. I didn't really look at it like that, but I think we're trying to make some type of beloved community in the Veterans Court where everybody feels comfortable. Like I said, there was no blueprint to start a Veterans Court or any treatment court. I just started it like I wanted to start, or I just did what I thought would be the most appropriate thing. And I never wear a robe or anything like that when I'm in Veterans Court. I'll come down off the bench. I'll mingle around in the audience and talk to people. I know their parents or their wives, or I know what branch of the service they were in, what they do for a living, what they don't do, what they're studying in school. And for me, it really works. And it was somewhere just actually, some people came in from Stony Brook University and did a big study on the Veterans Court. And we met with them on Tuesday, which I thought was really a waste of time because they're coming in, to me, is like mostly restating the obvious. But it was funny, one of the things that, and they had interviewed veterans, I didn't even know they were doing this, that were in the court, and one of the things that they felt bad about, or they really wanted to do well about, is because they didn't want to disappoint the judge, which I thought was really a cool thing. That and this was written down, that some people don't want to do drugs because they're afraid I'm going to be mad at them, which I never thought it would come to that. But it was it's weird how things really turn out. But it's almost the opposite of a court, and I know some of the people here have been in the court. But if you come in every day, you'll see on one side of the room it's just all green jackets or green shirts, depending on the season. And these are actually the backbone of the court. They're the mentors. Every veteran comes in, he has a mentor, and they really are, going back to what was brought up earlier with Cain and Abel, they're really their brothers. And when they say, where is your brother? Well, he's here, and there's one assigned to you, and he's walked in your shoes. And he knows what you're going through, and he knows how hard it can be to adjust from military life to civilian life, and how you can get trapped into drugs and alcohol, or how, if you have what they call PTSD, and you have alcohol and drugs, you can never get over the alcohol and drugs unless you treat the PTSD. And they realize that, they know this, and they encourage these veterans, these guys, to get through it. And I've been a lawyer and a judge for over 40 years. And it goes fast, I'll tell you that. It just seemed like I just got to law school myself. And I have to tell you, the most rewarding thing I've ever done in my life professionally outside of my family would be being the presiding judge of the Veterans Court. It's certainly my privilege to serve in this capacity. It's my privilege to work with both Dean Harry and Dean Rosenblum. I have them in your corner all the time. And Marjorie, I wish you the most success on your book. And I'll always remember, I think, when I'm in the court, those two words, beloved community. And congratulations.
Thank you so much. Thank you so much, Judge Toomey, and thank you, the Dean, for your opening remarks. I want to introduce the speakers to you, then I'll explain the format for the rest of the program and how I got involved in this project. So to my left is Nanette Shore, who's going to give you shortly a brief overview of PISLAP, the Project for Integrating Spirituality, Law, and Politics, out of which this book emerged. And Nanette is a supervising attorney for education and family law in Bronx Legal Services. Victor Good, my colleague at CUNY. Victor is professor of law at CUNY Law School, and if I recall correctly, one of the founding faculty members, and at one time associate dean of CUNY Law School, which is my second favorite law school. And then we have, appearing by the miracles of technology and thankfully to our IT team, Fania Davis, who is the founder and director of an organization called Restorative Justice for Oakland Youth, which has done amazing work using restorative practices in the Oakland school systems, and Pamela Donison from Phoenix, Arizona. Pamela is a self-described integrative family law attorney, which means she practices mediation and collaborative law in a way consistent with the principles of PISLAP. But before I proceed, I want to thank Linda Howard Weissman and her amazing team, including Taj Moise, who is the events coordinator, and all the other people here at Touro who make this work, Peter Stanisi and the IT team. I feel like this is network television with the setup they have going there. Carl Bowerly and his folks who do all the setup. All of you who have made the time to come this evening, my colleagues who are here, and because behind every successful woman, there's another woman. Special thanks to Kathy Sombrali, my faculty assistant, who has just been such a joy and such a support in so many ways. Oh, and I would be remiss if I didn't thank my research assistant, my current research assistant, Mayerline, and my former research assistant, Luann Delicanato, managing editor of the Law Review, who unfortunately had to go to class. The rest of it is Nanette is going to speak for a few minutes. And then I'm going to show you a 10-minute video, which features 11 of the 16 contributing authors to the book, briefly, very briefly, describing their chapters. And then Victor will say a little bit about his chapter because he didn't make it into the video. And then I'll pose questions to all of our panelists. And then we will open it up to questions from all of you. So without any further ado, Nanette Shore.
Thank you. I feel very welcomed here at Touro. It's great to be here. I was actually here, I think it was last year, as a guest presenter at Marjorie's class for her externs, or maybe the year before. And I really enjoyed meeting with the students and talking with them. So as Marjorie mentioned, the book really came in part out of her connection to PISLAP, the Project for Integrating Spirituality, Law, and Politics. And I'm the sort of co-organizer of that group, along with somebody by the name of Peter Gable, who you will see in the video. And I've been connected to that movement for 20 years now. PISLAP is a national network of lawyers, law professors, students, and others who are seeking to develop a new, what we call spiritually informed approach to law and social change. And it's PISLAP feels that law can play a really crucial role in helping people recognize and affirm each other's humanity. And that's a different conceptualization of the law than we often hear. In the words of Martin Luther King, who we've heard already tonight, talking about beloved community, we seek to create a legal culture where justice is defined as love, correcting that which revolts against love. Those are Martin Luther King's words. I think they're beautiful words. PISLAP's efforts play out in various arenas of the law, but our shared focus is on moving the legal profession toward a model of practice that integrates client needs with social responsibility, ecological awareness, and the creation of a socially connected world. So we're seeking integration of the two rather than conflict between the two. PISLAP emerged from a gathering back in 1996 of 1,800 social activists in Washington, D.C., at an event that was then called the National Summit on Ethics and Meaning. And this conference grew out of the work of Rabbi Michael Lerner, who is the editor of a magazine called Tikkun Magazine, and Peter Gable, who, again, you'll see shortly, who is a law professor then at New College of California and has taught elsewhere since. And it was based on the idea, the conference grew out of the idea, that progressive social change really requires a new vision of human beings, one that accepts that not only do people have urgent material needs for economic well-being, for housing, for employment, for just the daily stuff of life that many people are deprived of, but that also have a very deep longing for community, for a sense of purpose, for a sense of meaning. And sometimes that longing is not as fully recognized. When we talk about social activism and social justice, we tend to focus a lot more on the economic. So we took that vision and that idea and tried to bring it into the law and the legal culture and say, well, what would it mean to have a legal culture where people's need for community and for social connection was fully recognized? And so at that conference, we delivered this platform on transformation of the law in that direction. And we said, anybody interested, come and talk about it. And 50 people came running outside afterwards. So there was a lot of really great energy. And so PISLAP really grew out of that conference and that initial meeting. And just to give you a picture of the kind of folks that were part of the group, in its early days, we had a corporate lawyer who was disaffected with the traditional corporate practice and was seeking to advise his corporation in being socially responsible. We had a prosecutor seeking new approaches to crime and social violence that could heal communities rather than simply punish individuals. And now we call that work restorative justice. And it's really grown hugely. I lost my mic here. It's really grown hugely since 1996. It's really now a national movement, both in criminal law and in schools, to do restorative practices to address school suspension and school discipline. We also had a patent lawyer who is still very much a leader in this work, who's looking for collaborative approaches to patent work. And how do you write a letter to the other side saying your product is violating the patent without just threatening litigation? Is there another approach that could actually recognize what the other product had to offer, but doesn't immediately descend into hyper-adversarial mode? So, growing out of the work of the legal task force, which came through, we devolved on a number of guiding principles: fostering the use of restorative justice, promoting transformative models of mediation in civil practice where that's feasible, transforming legal education so that in law schools students are encouraged to do deep listening to the stories of others, and examine ways to think about resolutions and remedies that foster mutual understanding. And then really looking at the practice of law from beginning to end, from the attorney-client relationship to the way we collect fees, and thinking about ways of organizing that foster social connection and community. We've done many things over the years, but I think a key component, in addition to writing and speaking, has been conferences that we've organized over the years in different parts of the country. And our most recent group of conferences was in 2015 at CUNY School of Law, a major PISLAP conference. In 2016, a conference on beloved community at Drexel School of Law in Philadelphia, where we had members of the Mantuan community that is around the school, very low-income community, come to the conference with us and be activists in co-creating the conference with the law school. And we're in the beginning stages of planning a conference in 2018 in Washington, D.C. at an area law school. So I guess I'll stop here.
Other than encourage anybody who's interested
Yes.
in getting on the listserv?
If anybody is interested in joining the PISLAP group list, come see me and give me your email, and I'm happy to join you. Thank you.
Thank you, Nina. Okay, because time was perhaps running short, I will reserve talking about a little more particulars about how I got involved in this project. And now we are going to screen a video, since we couldn't have all 18 authors here. You'll get more of a taste for what their various contributions were to the book.
You can.
I'm Peter Gable, and I was one of the co-creators of PISLAP, and my chapter in the book is called The Spiritual Dimension of Social Justice. The key point of that chapter is all social movements bring into existence as they rise, the very word rise suggests it, a new sense of mutuality, of presence, of social connection, of affirmation of one another in our whole humanity that is realized through the justice struggle and embodied in it. But our legal system that we've inherited from the 18th century is an individualist legal system that doesn't capture the core social spiritual dimension of who we are as humans, or of what the link between law and justice really is. So when that social movement gets into the legal arena, it has trouble recognizing and seeing its highest vision and values. And so PieSlap and this book are helping to create a vision of what a transformed legal system would be that could incorporate that aspect of us.
My name is Nanette Shore. I live in New York City, and I work as an attorney, as a supervising attorney at Bronx Legal Services, which is an organization whose mission is to provide free legal help to low-income people and to address racial, economic, and social justice. I'm also a co-founder of PieSlap. My chapter looks at my personal history, my life history, how I came to both legal services work and PieSlap, and how I have sought to integrate the two in the sense of bringing many of the ideas and insights of PieSlap about bringing restorative work and transformative relationships to community into my work in legal services, both in terms of client representation, in terms of working with our office culture, and in terms of building a strong community lawyering practice.
I'm Fania Davis, and my chapter in the book, our chapter in the book, is envisioning a truth and reconciliation process to address violence against African Americans in the U.S.
And I'm Jonathan Shar, the co-author of the chapter with Fania, and we look at addressing the systemic violence and issues related to extrajudicial killings and the intergenerational transmission of trauma and harm, and addressing that through the use of dialogical encounter processes to highlight human connection and find solutions.
My name is Sylvia Clute. I practiced law for 28 years, and during that process I discovered that there are actually two models of justice, vengeance and love. So my chapter in the book is about what might be called justice as love. I call it unitive justice. And in the book, I describe 12 essential structures of punitive justice, compare those to 12 essential structures of unitive justice, and I believe that comparing the structures in that way provides a compass for essential transformation that we need in our justice system.
Hi, I'm Susan Brooks, and I'm an Associate Dean and Professor at the Klein School of Law at Drexel University, which is in Philadelphia in the U.S. And I've been in law teaching for over 2 decades now, and my chapter is really about bringing my former background in social work into my thinking about, or how I've done that and brought it into my thinking and my practices as a law teacher. And the chapter includes a set of simple practices that could be brought throughout legal education that would help to create a beloved community, both in the classroom and in legal education and practice going forward.
My name is Bruce Peterson. I'm a judge in Hennepin County District Court in Minneapolis, where I've been for about 18 years and served in a variety of different divisions in that court. There's an evolution of consciousness that's going on in the world. It's manifesting itself in different ways in different fields and professions, in medicine, in the way people respond to the environment, in business practices. My chapter is about how this evolution of consciousness is playing out in the court system, and how my experience in my career has been affected by that. I've been a judge here in a number of our problem-solving courts. I think they're a wonderful example of a very different model of judging, where judges are supportive and facilitative with the people who are coming into their courtrooms, rather than judgmental and punitive. We've had a variety of problem-solving courts in Hennepin County that I've worked in. My chapter is about how that work relates to my own spiritual development.
Hi, I'm Pamela Donison, and I'm honored to be a part of Marjorie Silver's anthology, Transforming Justice, Lawyers, and the Practice of Law. My contribution is regarding collaborative practice, and I find it to be one of those healing types of practices because it allows us as attorneys to be problem solvers and helpers instead of adversaries. In my chapter, I give you a little bit of background about collaborative practice. For those of you who don't know anything about it, I talk a little bit about Stu Webb, whose chapter precedes mine, and he's really the founder of this movement. I then talk a little bit about some of the key players who brought the movement international. And then I go into an explanation of why I believe that collaborative practice is a political act for attorneys, because anytime you refute the dominant paradigm, which is litigation, you're making a political statement. I also talk about how collaborative practice is a spiritual practice as well.
Hi, my name is Stu Webb. I live here in Minneapolis, and I was the founder of Collaborative Law. I kind of developed it out of a desperation of letting go of litigation and finding some way to still be a lawyer. And collaboration with developed sort of to the result of it is sort of transformed litigation people into settlement people. And that's what my little column is about, how that came about.
My name is Jean Anselmo. I'm one of the co-founders of the Contemplative Urban Law program at CUNY School of Law. I'm a holistic nurse and a meditation teacher, and I've had the great grace for the last 16 years to be part of this amazing community who have been focused on social justice, but are looking to really go deeper, to really understand that personal transformation is the real core for doing deep work in our society. The way that we get there is through contemplative practice, through meditation. I have the great grace of having worked very closely with Victor Good, who's my co-author on this chapter. We hope that this chapter actually helps people begin to understand how that personal transformation, that spiritual practice is really an essential part not only of self-care, but of recognizing how we can really make the kinds of change, the lasting, sustainable change that we would want to see in this world by cultivating beloved community.
My name is Femke Weidekop. I'm a Dutch lawyer. I'm a co-litigant also in the climate case. And I feel very inspired and very blessed to have been able to interview earth lawyers and activists for my chapter called Voices for Mother Earth. I'm quite moved by the vision of those I interviewed on how we can move away from seeing the earth as a mere resource that we are allowed to use for our own good, towards realizing that we are in a relationship with the earth, that the earth is a being, and that our legal structure should give expression to that we are guardians, and that we have to take into account the consequences of our actions on the rest of creation and on future generations. I also think that the Urgenda climate case and other climate litigation like that's going on in the United States is showing that this more ecocentric and intergenerational view can have very practical relevance and can be a real powerful tool in order to influence climate environmental policy.
I know that Professor Kennedy, your students have to go to class now, and I thank you for staying. And of course, if you want to cut class, I never recommend that. Victor, because, Jean did talk briefly about your chapter, but what do you want to add?
I'll add a few points briefly. The work that we do at CUNY Law School, as my co-author Jean Anselmo pointed out, began 16 years ago. The contemplative practice program that we have created, I think, can be neatly divided into about 3 segments. The first segment, we initially attempted to respond to the reality of stress in the profession. Some of you may be familiar with the statistics and data that lawyers, unfortunately, exhibit uses of alcohol and drugs to respond to stressful events in their life at a rate almost twice as high as the national average figures. More recent research revealed that that process was not one that began after law school, but a process that began in law school. So we were attempting to provide our students with a healthy means through meditation of dealing with the stressful impact of law school and legal education itself, with the hope and expectation that it might carry over into their practice and provide them with an alternative way of dealing with those stresses once they were working. The second phase of our work was where we began to look at the importance, if not really the critical importance, of not looking at meditation simply as an individual activity for one's individual worth and change, but to fuse that with the mission of the law school and the importance of social justice in our work. And so we began to come up with ideas and essays and different types of practices through our meditation work to begin to fuse these two ideas. The first is one of sort of individual self-awareness, and the second was implanting the seeds of social justice with the meditative practitioner. Meditation, for example, invokes higher levels of compassion and a sense of empathy that can extend not only between the relationship between a lawyer and a client, but also between a lawyer and colleagues, and even between lawyers and adversaries, lawyers and judges. Those barriers that our roles sometimes impose on us can be removed in some ways, or at least reduced through a meditative and contemplative practice. And as my co-author Jean pointed out, the third phase that our program moved into is one in which that work takes on a much, much deeper aspect, where we really seek to empower students through contemplative practice to go through a process of deep self-transformation. One of the things that's important to being able to sustain oneself through a life of contemplative practice in the law is to be able to resist the stresses and strains that will invariably come with that work. And we've seen many organizations and many fine lawyers try to sustain themselves through idealism and commitment alone. And what we've discovered is while those are necessary ingredients, that's often not enough. And a contemplative practice, we believe, adds that essential component that transforms idealism and commitment into a sense of deep inner peace, invoking a sense of deep compassion and commitment to others that will sustain that work over many, many years of practice.
Hold on. Peter, do you know what that noise is? It's the Zoom. Oh. Pamela and Fania, could you mute your audio for the time being? Okay, great. I'm sorry, Victor.
No, quite all right.
You're finished?
Yes.
Okay. Well, now, Fania, if you would unmute your audio.
Okay.
We're getting a lot of feedback there.
Okay. Yeah. Is that better?
That's a little better. Can you lower your volume a little bit more?
Yeah, I was having difficulty hearing you all.
Oh,
Okay.
sorry to
I
hear
was
that.
looking for a set of earbuds, but let's just proceed.
So I wanted to start, Fania, by asking you, it's been a while since you and Jonathan completed your chapter about healing historical and current racial harms. What, if anything, has occurred since then in this country to either help bring that into reality or to make that more difficult?
I'm having a little difficulty hearing you. Can you hear me?
Yeah, I can hear you fine. Did you hear the question?
Okay. I think I heard the question about whether things that have happened since the publication of the chapter have helped to bring this vision of a truth and reconciliation process into fruition or not. A lot has happened, obviously, since we published that chapter. And let me just say that our chapter it asks the question, how can we envision a justice that can heal historical harms? How can we envision a justice that can stop the police killings, this epidemic of police killings, knowing, of course, that our criminal justice system only has the capacity to prosecute individuals. And the problem we're seeing with the police killings and with other manifestations, present-day manifestations of racism, are not individual problems, they are systemic problems. If we successfully prosecute an officer, and that's a long shot, you know, but even if we did successfully prosecute an officer, that's not going to stop the killings. We need a more capacious understanding and vision of justice to heal those historical harms. And let me just talk a little bit about what I mean by historical harms. What I mean is that whether we're talking about racialized mass incarceration, the racialized school to prison pipeline, police killings, and all of the other present day manifestations of racism, they are present day expressions of, I think, the original trauma of slavery, of what happened with the birth of our slave nation and our genocide nation. And if we don't somehow, like a child who has a very early childhood trauma, if that child as an adult or as a child doesn't begin to heal that early trauma, that trauma will perpetuate itself. It will reenact itself perpetually in different guises. And that's exactly what we're seeing today. We got rid of slavery, but it returned in the guise of sharecropping. It returned in the guise of convict leasing. We got rid of those. It returned in the guise of lynching. We got rid of lynching. It returned in the guise of Jim Crow. We got rid of Jim Crow. Now it's returned in the guise of racialized mass incarceration, the school to prison pipeline, police killings, and so on. So our task, we say in this chapter, is to envision a very capacious and completely transformed notion of justice that can in fact heal those historical harms. Now, that having been said, let me just briefly talk about some of the things that have happened. We've seen a lot since we published the chapter going on in this country in respect to racism, in respect to protests against racism, in respect to truth-telling, racial healing, and reparations efforts. Because the justice that we envision would involve those elements: truth-telling, racial healing, and reparations. Of course, with Charlottesville, we saw this eruption of white supremacy with the killing of an anti-racist activist and the wounding of others. And of course, we also saw massive counter demonstrations all over the world, which is really beautiful. And one of the things that we saw, which I took note of, was all of the Confederate memorials coming down, streets named after Confederate generals being renamed, flags. Well, the flags actually started coming down after Charlottesville. I mean, after the Charleston massacre. But we've seen a lot of that. And that is what we would like to see when we talk about truth and reconciliation processes. Not just truth-telling about the origins and the roots of the racism that we see today in our country in slavery, but actions like taking down Confederate memorials. In Germany, Germany can be a model for us. There are no statues, of course, of Hitler. There are no statues of Goebbels. And they have a transformed curriculum that tells the truth about what happened during the Holocaust. Teachers are required to teach it. They're required every year to do continuing education so they can teach it better. Young people are required to visit the thousands of memorials that exist in Germany, remembering victims of the Holocaust.
And in terms of bringing this down to the community level, which you didn't get into, but it's in your chapter about actually starting a grassroots level of having people talk about the truths of their experience. Has that been occurring in this country? Anything like the Greensboro Truth and Reconciliation process, which I believe was in the early 1990s?
I couldn't hear you very well. I'm sorry, I had to turn it up. I hope the feedback isn't so bad. But are you asking whether we are seeing dialogical encounters where people are
really talking? Can you hear me
engaging in
better?
racial healing discussions? And is that what you're asking?
Yes, yes.
Oh, yeah. Yeah, we're seeing more of that. We're seeing, you know, I think after actually Trump was elected, we saw a real kind of mushrooming of anti-racism, especially amongst white activists. Movements like Showing Up for Racial Justice, it's an organization, a national organization, it now has 200 chapters. You'll find a lot of social media web pages that are dedicated to unlearning white supremacy and white privilege. You're seeing more and more trainings on unlearning, on implicit bias. In the restorative justice movement, we're developing whiteness trainings where white people in affinity spaces are able to confront their own white privilege in ways that don't cause them to shut down because of defensiveness, which can happen if the space is a multiracial space, and then Black people and people of color end up having to comfort white people who feel like they're being accused of being bad or being racist. And so, you know, those kinds of attempts to educate white people about their own white privilege have not been very successful. So we're creating these affinity spaces in circle so that white persons can in a very deep way engage in this self-inventory, unlearn their own white privilege. So we're seeing, a lot of good things are happening. In addition to the racial healing dialogues that are growing, that organizations like Coming to the Table are doing.
Thank you. And now to segue into a rather different field, but still certainly connected to transformation, I want to ask Pamela if she would, your practice is mostly in family law. Maybe you could just briefly describe how the collaborative practice works and what its applications might be in commercial or business law.
Thank you, Marjorie, and thank you, Fania. I love your approach, and I honor you. So collaborative practice is basically a team mediation approach, if you will. That's a shorthand way of describing it. So instead of two parties having two adversarial attorneys, in a collaborative practice model, you have two attorneys who are more like co-counsel, working on the same team for a common goal, which in a divorce or family law situation is to resolve the differences of the parties in a peaceful way that is a win-win instead of a win-lose. So you would have two parties, there are two attorneys, and you may also have team members. So the team members are most commonly a mental health professional who acts as a communications coach, and you may have two of them or one as a neutral, a financial expert who would be a certified divorce professional analyst. So that person is the financial neutral on the team. And then you may also have a child specialist, again, who's a neutral and who's not there in the role of a custody evaluator, but more in the role of a child development expert and a parenting coach. So those are the basic team members. And in that model, what falls away is the threat of "I'll see you in court" or "my lawyer's going to kick your lawyer's butt." That goes away because both of the lawyers are working on the same team. And when you move that model actually quite easily into other areas of law, you can see how applicable it is. And right now in the US, I'm aware of 3 or 4 groups that are working on using the collaborative practice model in estate planning or probate issues, where a family may have a dispute over dad's will, using it in medical malpractice cases, where very often we find that obviously there's no amount of money that is going to bring back a loved one, and often it's the dialogue that the family is seeking, the apology and the conversation around what happened. And then another place that we're seeing it applied is in civil contract situations, because when you are in a civil contract with someone and there's a breach or a default, obviously these are people that want to work together. They didn't come into this to fight. They want to have a business relationship. And so using that collaborative model allows them to move past the dispute and go back to work without having years and years of litigation over a widget that didn't work, for example. So that's how the collaborative model can be applied to other types of law, and quite successfully.
Great, thank you. Victor, I'd like to ask, in a sense, a similar question of you. You've talked about CUNY's program and the use of meditation and other contemplative practices to help social justice lawyers sustain their work in the long run. What, if any, application does it have in the business commercial practice of law?
Well, one thing that's very interesting from the contemplative practice world is that we're getting increasing participation and literature from persons that are in fact, the business world. And they do begin to see that business and commercial activity plays a vital role in the life of any community. That role does not have to be extractive or exploitive, as some business unfortunately are. It can be productive, supportive, and integrative into the things that a community needs and a community does. A contemplative practice, I think, allows a business lawyer to begin to develop those themes more effectively, to see them, to weather their ups and downs, which are inevitable in any area of the practice of law, and once again to be able to kind of sustain a sense of deep values in the work that they do.
And what, if I could just dig down a little further in terms of how contemplative practices help one distinguish between reacting and responding to difficult situations?
All of us react to stimuli. And one of the things that we teach our students in our contemplative practice work is that you might think of the stimuli coming from this direction and our reaction coming from this direction. And unfortunately, many of the things that we think of as our own thoughts, our own feelings, our own ideas are often things that are deeply planted in our subconscious and almost rise to the surface automatically. And yet we claim them as part of a deep thinking process. A contemplative practice, one that involves meditation, begins to open up some space between that stimulus and our response. And as that space begins to open up, we're truly able to distinguish between those things that are part of our background, our psyche, our subconscious, and those things that are really part of our conscious deliberation and actual choices. And in the world of lawyering, that can be an extremely valuable skill to learn how to listen deeply, to hear what's really there, and also to develop a deep sense of self-awareness so that as we respond, we are reaching our own deep responses and not things that are simply automatic or programmed.
Thank you. I think I neglected in advance to thank our speakers, so I want to thank them now before we open it up for any questions. And I know that Fania has to leave for another engagement in about 35 minutes. So if there are any questions of Fania, and if not, any questions of Victor, Pamela, Nanette, myself? Yeah, Marilyn. Oh, I think we better give you, or I could repeat it. Hold it close and talk loud.
My question is, how do you address the potentially prohibitive cost of collaborative divorce? How do you deal with, let's say, a low-income client who may be in need of it but cannot afford the team? Are there any efforts to help with that, basically? Did she hear it?
Pamela, did you hear the question?
I only heard a couple of words that it's very difficult to hear.
Okay, so, but you can hear me now, so I'll repeat
Yes.
the question, which is, how do you, given the costs of collaborative practice, of the team approach, how, if at all, can that be made available to people who don't have those kinds of financial resources? Is that a fair statement, Aileen? Yeah.
I'm sorry, so the question is, how do you offer the team approach when there are limited resources?
To people, yeah, to people of limited means, or is this really only something that people with a good deal of resources can have access to?
Well, I think that's an excellent question, and it's certainly something that we have struggled with because the harsh reality of our society is that there are a lot of people with no access to legal services because of the monetary barrier. That is true across the board. There are some practice groups. I believe King County in Seattle is one of them, and I believe the Minneapolis practice group is another, that they've created a fund that they can offer services to low-income families on a limited basis. But other than that, I think that the important thing for consumers of legal services to understand is that in the continuum of services, a collaborative divorce is a fraction of the cost of a litigated divorce. And people very often, I mean, I've come across this 100 times in my own practice, when you talk about the collaborative team, they go, oh my gosh, no one can ever afford that much. But what is the piece that people often miss is that when you are shifting the role of financial advisor and counselor and therapist from the attorney to the appropriate professional, your legal fees go way down. Now, the cost of those other professionals goes up, and in my experience, 99% of the time, those other professionals' fees are about half or less of what an attorney charges. So instead of me writing a parenting plan at my billable hour rate, a child specialist may be writing that parenting plan with the parents at a rate of a third of what I charge. And so when we look at the economics of how a collaborative team actually works, in my experience, it is far more cost effective than using 2 attorneys to litigate your case. It is going to be, in most cases, more expensive than mediation and less expensive than litigation. So it's a matter, I guess, of a family prioritizing what services they A, can afford, and B, that they actually need. And that reality has pulled a lot of groups, a lot of collaborative practice groups away from the full, what's called the full team model, meaning you are required to have one of everybody, into a more relaxed model where, for example, myself and opposing counsel may get on the phone and say, what does this family really need? Do they really need a financial expert, or are their finances simple enough that it can be managed by them? Do they really need that child specialist, or have they got a couple of
teenagers that are going to be out of the house soon, and we don't really have to work that hard on creating an elaborate long-term parenting plan. So there's ways, I think, to impact that cost, but I'm going to be completely honest, it is always going to cost more than mediation.
Thanks. And then Annette, you're used to dealing with a different client population. Do you want to say something about that?
Although this is not the collaborative model that Pamela is discussing, in legal services in New York City, I've played a role in starting a divorce mediation project. And what we do is attorneys who are normally litigating attorneys are trained as mediators. And we do it as a team. We mediate the divorce, and we get 2 pro bono lawyers to be outside consulting attorneys for each party, so that attorneys can explain their rights, they can review the mediation agreement. They don't sit in on the mediation, but they're there for advice and counsel. So, you know, it's not the collaborative model, which is a wonderful model, but it is a very powerful model as well, offering people mediation.
And a model that's perfectly consistent with the vision of finding more healing relational approaches to resolving conflicts. Eileen. I'm going to bring you a mic.
Arguments in support of the collaborative and contemplative practices you describe are really compelling. But I can't help but wonder, and maybe this is for Victor, when you described stopping and making sure you're not responding by instinct and really thinking before responding and thinking deeply before responding, that how that plays out in today's so polarized world. And on a broader scale, the various practices that you've described, doesn't that successful practice require good faith on, I'm saying on the other side, and I know you're trying to move us away from thinking of this in an adversarial way.
This is actually a question that many of our students ask. Part of our program has evolved to the place where we actually teach a 1 or 2 credit course. And we're able to really explore questions like that from the fairly broad range of literature that's now available. And students often ask themselves, basically, am I going to lose my edge? Am I going to become so gentle, so empathetic, and so sympathetic to all of the parties involved in this dispute that I'll lose my sense of my role and my responsibility as an advocate for my client? And what we've discovered through our work, but more importantly, the information that we've received from practitioners in the field who actually employ these techniques, is that's not the case at all. In fact, it makes them more effective because they are better listeners. They do pick up cues more carefully. They don't feel bound by roles. They're able to pursue what's going on in that moment, both with themselves and with the conflict that they're trying to adjust on behalf of their client. And so they have written extensively about how this actually improves their advocacy rather than dims it in any way. And one of the things that I want to sort of emphasize about this sort of contemplative approach is that it's really not thinking about. It's really not thinking about. It's using the skill that we develop through deep meditation so that these processes begin to rise to the surface almost automatically without relying on the normal logical cognitive thinking process that we typically employ as lawyers.
If I could just add to that briefly, in terms of entering into the collaborative divorce process or mediation, you're absolutely right that both sides have to agree to that. What Victor said about contemplative practices, I truly find is true no matter whether you're facing a really contentious adversary or someone who is far more reasonable. But many of the dispute resolution processes, or even a participant in a problem-solving court has to basically agree to give up certain rights. So there are certainly aspects of this which limit choice, and litigation, in a sense, is the only process where you can compel people to participate in dispute resolution or adjudicating criminal charges. Any other questions? I mean, we have run over, and I really appreciate the patience of Fania. Did you want to say something? You're muted, I think. You're muted.
Yeah, I'm going to head out now to make my
Yes.
next appointment. Thank you
Okay.
so much.
Thank you so much.
Thank you, Marjorie. Congratulations. I can't wait to read the whole book, and we'll be in touch. Thank you.
Okay,
Bye-bye.
thank you. And Pamela, thank you so much as well. And thank you to all of you who have stayed till the end. Yeah, well, hopefully there are lots of people out there watching live stream.
Okay.